And okay, so for today's session, we are really privileged, yes, and very glad to have the chair of the MBA section of legal practice, Mrs. Folashade Ali, on the call. So, ma'am, Mrs. Folashade Ali, SAN, yes. Let us see. We would like to take your welcome remarks before we start the session.
Thank you very much, Damilola, and good afternoon, everyone. I thank you all for joining, especially to our speakers and participants who have joined on time, and friends of sectional legal practice. I welcome you all to this very insightful webinar that's titled Data Governance and Legal Compliance in Digital Age, which is being organized by the Technology, Media and Telecommunications Law Committee of the Nigerian Bar Association section on legal practice. I think I must commend the committee of the Technology, Media and Telecommunications Law Committee, which is ably led by Fernandez Marcos, and Damilola and all your team, honestly, for organizing these weekly sessions on tech and media. It's really, really commendable because you want all of us to become tech savvy, especially people like us. We all know this is crucial to the development of law, as data governance and legal compliance in digital age is really welcome. So thank you all. We all live in a world where data obviously has become one of our most valuable assets that we all must have. And with this immense value that we're going to learn today, I believe that we can only be better off. This webinar definitely is timely, and I will continue to just thank my team for ensuring that all lawyers understand what it means to have data, the laws governing it in the digital age that we all live in. Thank you, my speakers, Mercy Jackson, Okocha, Sir Stephen Lakwe, and others who are going to give us a very intellectual and I believe a rewarding session on data governance. I encourage everyone who have joined us to listen, take notes. I plan to do so, and I plan to be actively involved. My profound appreciation again to everyone that has joined. I hope that we'll all leave this webinar inspired and better equipped to position ourselves and indeed the Nigerian legal profession for the next frontier of growth and excellence. Once again, thank you all, and I welcome you. Enjoy this productive and educative session. Thank you. Thank you.
Thank you so much for that very inspiring and short welcome remark, Leonard. So before we start, before I hand over to the moderator, our moderator is waiting already. Before I hand over to the moderator, a few housekeeping rules, please. Dear participants, there will be no need to drop your Supreme Court number or your personal details in the chat box. We would not be needing that for the ICLE certificate. Provided you register for this webinar, you will get your certificate. And so I will be handing over to our moderator, Chidera Ike. Will take over from here and yes, handle the session going forward. Chidera, over to you.
Thank you so much, Damilola. Thank you, everyone who is on this call. Thank you also to the Leonard Silk for the welcome remarks. Like Damilola said, my name is Chidera Ike Okonkwo, and it's my pleasure to be the moderator for this session today. I'll quickly begin by introducing the speakers. I will just read out their short profiles. Afterwards, the first speaker will be Mercy Jackson Okocha, and then afterwards we'll hear from Sir Stephen Alekwe. Mercy Jackson Okocha is a dynamic legal practitioner with over a decade of experience in legal practice and regulatory compliance. She's an accomplished compliance expert in the fintech space with over 5 years experience championing data protection and privacy governance within corporate organizations. Her extensive background includes developing and implementing governance frameworks, compliance programs, and internal control systems, specifically in data governance. She has successfully championed data protection and privacy governance within corporate organizations. Her initiatives have improved data protection and privacy programs, achieving 98% compliance with regulatory requirements. She has been instrumental in developing the first ever data privacy program for a fintech organization, which led to high compliance ratings during regulatory audits. She possesses deep expertise in data privacy, regulatory compliance, and corporate governance. She's currently the head of legal compliance and operations at Vericross. Mercy provides strategic oversight of data privacy and consumer protection programs, embedding a compliance culture across all departments. She holds an LLM from the University of Birmingham, United Kingdom. She is a certified designate compliance professional by the Compliance Institute of Nigeria. Ladies and gentlemen, I know that we're on a webinar and we may not be able to clap, but if you can drop a clap emoji in the box, let us appreciate our speaker, Mercy Jackson Okocha. The next speaker is Sir Stephen Alekwe. Sir Stephen Alekwe is a digital trust professional and licensed data protection consultant whose expertise spans information systems auditing, data privacy engineering, financial management, and enterprise governance. He's a certified information systems auditor, a certified data privacy solutions engineer, a fellow of the Institute of Chartered Accountants of Nigeria, as well as an ISACA DTEF certified trainer and ambassador. As a seasoned banker and turned multidisciplinary professional, Sir Stephen brings extensive experience across financial management, professional accounting, risk oversight, and data governance. As the lead consultant and chief data protection officer at Headspace Resources, Stephen Alekwe & Co., an integrated consulting firm and a licensed data protection compliance organization. He leads training, auditing, and compliance engagements that help organizations to meet the requirements of the Nigerian Data Protection Act 2023, as well as other applicable data frameworks. He's dedicated to advancing digital trust, privacy governance, and responsible data use. Sir Stephen continues to influence both industry and policy conversations across Nigeria's evolving digital ecosystem. We're honored to have him in our presence today. A round of applause for him in the comment section. And at this moment, I would like to introduce Mercy Jackson Okocha, who is going to be our first speaker for today. She will speak for approximately 30 minutes. Afterwards, we will hear from Sir Stephen Alekwe. And after that, we will have a short Q&A session. So over to you, Mercy Jackson Okocha. Thank you very much.
Thank you very much. I'm really honored by the introduction. Thank you so much, Chidera. Good afternoon to our chairman of the committee, distinguished, my lords here present, distinguished Learned Silks, and my colleagues. As Chidera already introduced me, my name is Mercy Jackson, and I am honored to present this webinar to my colleagues here present. Thank you for this opportunity to share my knowledge. Thank you for the opportunity to be here, and thank you for creating this avenue for continuous learning. And like the chairman said, we must be tech savvy. Lawyers are not left behind. We will go through this trend and then we will succeed. Thank you. I don't know if you can see my screen. I'm currently sharing my screen. So if you can see, please just give me an indication. All right. Thank you very much. Thank you. So I have 30 minutes. I will try to run through my slides as quick as I can. But please, if you have questions along the way, feel free to drop them in the comment section so that the moderator will pick it up and then we can address them at the end of my session. So today we will be discussing legal accountability and data compliance in the digital economy. So this topic for me, when I got the invitation, right, it was so timely because given the era that we are in, data is a valuable commodity. It drives a lot of business decisions globally. And if not handled responsibly, right, it could result in fundamental violations of the people's rights. So at this pivotal moment in legal practice, where data is no longer like an IT asset or an IT responsibility, it has now become a regulated currency. So look at data as a weapon that if it's in the hands of the wrong people, it could be a weapon of mass destruction. And that is me not putting it lightly, right? So the passage of the Nigerian Data Protection Act has fundamentally shifted the landscape from best practice to statutory obligations. So it's now imperative on every corporate organization that collects and processes data to ensure that those data entrusted to them are adequately protected. So my goal today will be to walk you through not just the law, not just what the law provides, but the practical application of accountability and compliance in this new digital era. So please, let's just relax, listen, flow with me, and I will ensure not to confuse you with many big grammars. Thank you. Next slide. Okay. So today's discussion will capture the following things: the core concepts of privacy and data privacy and data protection. I know that we usually interchange that, so we'll have to clear that so that we can have a better understanding of what it entails. We'll talk about the economic shift from the physical economic era to the digital era. Then we'll talk about the systematic risks to personal data. We'll also talk about the legal frameworks. And I'll also explain and clarify certain key terminologies that we'll be using along the way. Then we will now delve straight into the crux of this discussion, which is legal accountability, data compliance, and then we conclude. So now, what are the core concepts? Privacy versus protection. So data privacy and data protection are two different concepts. Yes, they are used interchangeably, but for clarity, data privacy is the right? Is the fundamental human right of an individual. So this right is protected under Section 37 of the 1999 Constitution as amended, and it guarantees privacy of citizens' homes, correspondence, telephone conversations, etc. So in addition to this constitutional right, the Nigerian Data Protection Act provides a comprehensive legal framework for protecting personal data of Nigerians. So as we will see in subsequent slides, the Nigerian Data Protection Act provides a list of privacy rights. So aside from your right to privacy, you still have your data privacy rights, and those are embedded in the Nigerian Data Protection Act. So essentially, data privacy is about individuals' autonomy. It answers the question, who is collecting my data and why do they need it? Do I have a choice to give that data? So imagine a client walking into a hospital. Now, data privacy is their right to decide whether or not to disclose their illness or genetic illness or the history, their medical history, right, to the receptionist. It's their right. They have control over the information they give. So now moving on to data protection, right? It is the mechanism. It is the how. It encompasses the legal, technical, and operational tools that are used to safeguard privacy. So now using that same hospital example, like data protection involves how would the hospital protect the information that you have given them. So protection now is like the password to the doctor's computer, the encryption to the database where where patient files are stored, or the NDA signed between all employees of the hospital and the hospital. So those are protection mechanisms that an organization must adhere to. So a patient's privacy right is a theoretical concept. Then data protection now brings it to life. So it's about security, it's about compliance. So talking about economic shift, right? We have moved from the physical to the digital. So the physical economy placed heavy reliance on physical capital, like factories, oil machinery. So it's in such a way that things are tangible, the assets were tangible. While in the digital economy now, we have like value for intangible data. So data is so valuable that it can be used to take decisions of various kinds. It can be reused, overused. So my data now in the hands of Zenith Bank could be used for another purpose in the hands of MTN. but they are all still the same data, but they take different forms. So this data now, in this current dispensation, let's think about Uber, right? Uber has physical assets. They have some physical assets like cars, but they are able to build a multi-billion-dollar company entirely on data that is matching customers' information, which is location, with another rider, with a driver. So a rider and driver connection. So this means that the shift to data is now a primary target for criminals because it's also a primary asset to corporations. And it needs to be adequately protected, just like the way we protect our currency, our fiat currency, our digital currency. Data ought to be protected in that way as well. Because like I said earlier, if put in the hands of the wrong people, it is catastrophic, right? So we are no longer protecting, as lawyers and as privacy professionals, we are no longer just protecting lands via deeds of assignment and power of attorney. We are now protecting digital identities. In the contracts that we draft, in the legal advisory that we give, data privacy and protection are all encompassed into it. So as legal practitioners, we cannot isolate data privacy compliance from our day-to-day legal practice because even the client's information that we collect needs to be adequately protected, and you need to know how to protect it because it's part of your duty of care and your responsibility as a legal practitioner. That's aside from working in fintechs or data companies, right? So moving on to the next slide. So what are the systematic risks to personal data in this digital economy? Knowing the value it brings. Like I said earlier, it helps companies know the sort of services they can provide, know the sort of improvements they can make to their applications, know the customer habits to be able to drive growth. So it's a valuable resource in the hands of the right people. So what are the risks? We have cyber risk and identity fraud. So imagine MoneyPoint, for example, has a data breach. Imagine that data breach, imagine the information that these hackers would have access to. So it doesn't just affect the company, it exposes millions of Nigerians to immediate financial theft and identity fraud. That is the best way I can explain this risk, the risk of cyber risk and identity fraud. So imagine someone taking your NIN, your BVN, and your email. That alone, and your phone number, that alone, those four information alone can create an alternate identity. And someone can use that to open up an app with maybe a non-compliant financial institution and carry out certain criminal activities. And then you see the police trying to look for you and you're wondering, when did I commit such a crime? Right? So that is the consequence of identity theft. So it just goes to show that this risk is enormous. Then we also have algorithmic bias and discrimination. So that is AI models being trained, right? Currently, we see a lot of HR tools having such AI models. Now, they can unconsciously automate discrimination based on the type of data that is being put in. So anyone that is, because it's garbage in, garbage out, whatever you put in is what the computer will give you, right? So we humans can put in certain historical data where men are mostly hired for certain tech roles. And this algorithm systematically reject female applicants today. And this violates the fairness principle and opens the companies to litigation. So it's important that we understand that this systemic risk to personal data must be curbed through legal accountability and data compliance. So what is the legal mandate that helps to protect and protect personal data and manage this risk? The Nigerian Data Protection Act 2023. It's the principal statute that has been enacted. It complements the NDPA, which is the Nigerian Data Protection Regulation that was issued in 2019. So it elevated data protection from a subsidiary legislation to an act of the National Assembly. So it is worthy to note that, oh, my apologies. It is worthy to note that the Nigerian Data Protection was initially issued by NITDA, which is the Nigerian Information Technology Development Agency. And it was issued as a subsidiary legislation, which was the first comprehensive regulation specifically for data protection. So with an enactment of the NDPA, the Nigerian Data Protection Commission was now established as an independent powerhouse regulator. So that goes to tell you how important data privacy is in this digital era. So subsequently, the NDPC now issued guide in 2025, which stands for the General Application and Implementation Directive. So that is the operational playbook, right? What guide seeks to do is to bridge the gap between the abstract law, which is the NDPA, and the daily practice, that's the operational activities around data privacy and data protection. So the guide converts the broad principles encompassed in the statute into certain areas of data compliance and legal accountability, as we'll see during the course of this discussion. So now, guide now brings more clarity into our day-to-day operations for handling personal data. So essentially, the act was enacted and the directive was issued with one goal in mind: to enforce and to protect the data privacy rights of Nigerian citizens. Now, before we delve straight into the discourse, like I mentioned earlier, we have data privacy rights, right? So what is data privacy and data protection without the rights? So this is essentially the crux of all that data privacy and data protection represents. So you have the right to information. You have, because of time, I won't be able to go deep into all of it, but I'll just, it's the ones that need explanation, I will expound on. Right to information, that's the right to be clearly informed about the processing of your personal information. I'm sure most of us have seen privacy policies that are on websites. Once we're about to onboard on a platform, we see certain privacy policies. That is our right to know the processing activities that our data, personal data will be used for. Then the right of access. Once you give your information out to a data controller, this term data controller too will be explained. I'm not going to presume that everyone here is familiar with the data privacy and protection lingua. So we will definitely explain these terminologies as we go. You have the right to access, to obtain a copy of your data that they have in their possession. As a DPO with Fair Money, we have so many requests, right? You know, because it's a loan company. Fair Money is a loan company. And, and what happens is that people get messages concerning debts and they will write to us, please, this and this and this are the information I need. What do you have on me? These are the informations I need. And how did you get my information? It's their right. So I end up having to draft an email, a comprehensive email, responding to their requests and showing evidence of how we got their information. So the problem now will be when they ask for that information and we do not have a response. And that is where data compliance comes in. Right to rectification, the right to correct inaccurate or incomplete personal data, the right to erasure, that's the right to be forgotten. Although it is not an absolute right, because we have other legislations, that's AML legislations, that allow us to retain data for a certain period of time because of money laundering activities, right? The right to restrict processing, the right to data portability, that's to receive your data in machine readable format and to move it from one data controller to the next, the right to object to continuous processing based on legitimate or public interest, and then the right for automated decisions, so not to be subject to harmful decision based on automated processing. So those are your rights, and these are provided under Section 34 to Section 40 of the NDPA. So what are the key terminologies so that you don't get lost when I start using them? So these key terminologies, these are the core components. This slide particularly, they are the core components. So data privacy and data protection seeks to protect individuals, protect their personal data, against unlawful processing. So now, when a layman hears this word, they are confused. Okay, you've used like 3 different phrases. What does it mean? Who is a data subject? A data subject is essentially you and I, human beings, natural, living, breathing human beings, right? It does not apply to corporate entities, only natural persons. People that can be identified. What is personal data? Personal data is any information. That is the valuable data we're talking about. Information, digital era, data. It's information. Data is information. But in terms of personal data, now, we have different types of data. It could be numeric data. It could be system data. But in this case, we're talking about personal data. So these are the information that belong to the data subject. That is the individual. So it's any information relating to a data subject that can identify, single out an individual. So it could be your name, your ID, your BVN, your NIN, your home address, your email address, your location. So for example, if I say, if I'm publishing something and I say, oh, Chidera of Africa told me this. Now, although Chidera's name was mentioned, can it actually identify her on its own? Maybe she said, oh, Chidera from Africa said a particular thing to me. She cannot be easily identified. So specific information that can single you out as a person is what we call personal data. So processing is what the law also tries to manage. Processing is any activity, any operation, any action performed on personal data. So that is, it stems from collection, storage, recording, transmission, deletion, transfer. So let me give you an example, a literal example of processing. When you download an app and a form questionnaire comes in for you to be onboarded, that is a processing activity by the data controller, which is, for example, could be Zenith Bank, PAMPay, or OPay. They are collecting your data. So they have already commenced processing your data. So processing does not just end at collection. Anything they do after that with that data, even reading it, reviewing it, is a processing activity. So any action, operation performed on personal data. So we'll go further to talk about the actors and their roles, because it's part of the key terminologies. You recall I used the word data protection, right? Data controller. And now you have a definition of data controller. So data controller essentially are the decision makers. So people that process data are categorized into data controllers or data processors. So they are 2 separate entities on their own. Data controller, data processor. So data processors are the decision makers. They determine the why, they determine the how. So a bank that decides to start doing a loan business and launches an app and asks people to use that app to collect loan, that bank is a data controller because they decide the why and the how. So the how and the why is to when they collect that data, they determine how they will use it in relation to the services they'll be providing to you. Meanwhile, a data processor processes data on behalf of the data controller. Stay with me. Data processor, let me just call them an enabler. They are the service providers. So now let's use the bank app analogy. So when you have a bank app for loan, for you to obtain loan, before your loan is approved, that information goes through credit bureau. It goes through a KYC application that does AML screening. It goes through an identity verification software. That's where you do that facial ID verification to match it against your BVN or NIN before they approve your account. And it also goes through other type of APIs that are integrated to that app. So Smile Identity is a data processor because they are embedded, their API is embedded in the bank app to enable the customers verify their identity through their API. So that's Smile Identity as a service provider, in brackets, data processor. Then we have the credit bureaus that check whether you have a pending debt or whether your credit score is good. They are data processors because on the instruction of the bank, they are processing data for the bank to take a decision on whether to give you loan. And even if they are going to give you loan, those same service providers and API integrations help to determine how much loan they will give you. So that's how data processing works. They act only on the instructions of the data controller. So one critical thing that lawyers should note, that's so that I don't forget, when drafting data processing agreements, I often review, like do a counter review from other parties of data processing agreements. And I see that they do not even really emphasize on the obligations of the data processor. So we should clearly define these roles in our data processing agreement because liability shifts. The data controller assumes full responsibility. But what happens in the event that the data processor starts using the data for their own marketing or marketing their own products, right? So there should be clearly defined roles, clearly defined obligations, and consequences. So I just wanted to drop that, by the way. Another key terminology that we'll be using in the course of this session is sensitive personal data. So that is different from personal data. The reason being that the word sensitive shows that this category is a special type of data. It carries a higher duty of care and stricter processing requirements. So, for example, like the hospital, in the hospital scenario I painted earlier, you walk into the hospital and you give a doctor your health background, right? And then you give them the information concerning your health status. Let's say your HIV status, for example. Now, before they share that information with anybody, they need your explicit consent, not indirect, not checkbox, explicit consent, because this sort of information are special category and it carries a higher standard of care. Things like genetic and biometric data, health data, sexual orientation, religious beliefs, political opinions, race and ethnic origin. People that collect this data are held to a higher standard. So if your client, for example, is a startup using facial recognition, that's biometrics, most fintechs use it to onboard customers, right? For ID verification, just to match it against your NIN or BVN. So this sort of onboarding already places them in high risk. They have a higher duty. So anyone that collects this sort of information must do a data protection impact assessment. It is mandatory. So not just because they're a small organization and you think when we say they are data controllers of higher importance, right? No. Once you collect certain sensitive personal data, you must carry out a DPIA. We'll talk about what DPIA entails subsequently. So now that we have understood what these terminologies mean, let's just go straight into the discussion for today. The topic, again, is legal accountability and data compliance in digital economy. So what is legal accountability in data privacy and data protection? So this is the obligation of data controllers to demonstrate. So, we have the law. The law is clear as to what you should do. The law has written down, giving you a framework, giving you a strategic roadmap into data compliance. So legal accountability is now the obligation to demonstrate. So it shifts the responsibility from being reactive, that's to being proactive. So like I mentioned earlier, we are moving from best practices to statutory obligations. So any company that collects personal data must demonstrate compliance or they face consequences for failure to adhere to this regulation. So the burden of proof now is on the data controller. So if NDPC, that's the Nigerian Data Protection Commission, comes knocking at your door, the burden is on you to produce evidence that you are compliant. You can't just tell them, oh, we are compliant. You have to show them policies, you have to show them audits, you have to show them your logs, you have to show them your data governance structure, right? You have to show them all the compliance that you have done, registration with NDPC. So for example, when a breach occurs and the regulators are investigating and they ask you to show us your privacy policy, show us your staff training records, show us your audit report. If you cannot produce this, you have failed the accountability test, regardless of why the breach happened, whether or not it was your fault. We know that security is not 100%, but there is a minimum threshold for compliance, minimum. And it's all contained in the guide, and it's all contained in the legal framework. So if you are a DPO or you're a legal advisor taking a dual role as a DPO in an organization, if you do not have evidence of compliance, please go back to the drawing table and get your house in order. Because now NDPC doesn't tell you, they don't announce when they are coming to do their routine checks. They will just sneak up on you like a thief in the night, and then you start running helter-skelter. So, but with this training, I'm sure we'll be able to go back to the drawing board and see where the gaps are in our clients' data compliance structure. So part of legal accountability, number one, is appointing a DPO. That is a data protection officer. Most organizations do not see the relevance in this. I have worked for over 4 startups globally. They do not see the relevance until the regulators come knocking or until investors come knocking. In one of the fintechs I worked as the legal and compliance manager, right? When I was brought in, they had no structure, no compliance structure whatsoever. What they brought me in was basically for AML and KYC, right? Because they developed an app and they needed to just get their AML because they were licensed, they got licensed by CBN and they needed a compliance person. So by the time I set up the AML compliance structure, I now informed them that, oh, we need a data governance structure. They said, no, leave that one, leave that one. I told myself, you know what? I can't be in this position and I'll be embarrassed. I can't do that to myself. What I would do is I will start creating a structure ahead of any issue, because what will happen is they can throw you under the bus and say, oh, we have our compliance person, meet Mrs. Jackson, let her explain to you what data, and I'll be like, but I told you, let us do this. So the onus was on me to either follow them in their ignorance or do the right thing and later bring them on board. So a few months into my employment as the compliance person for that fintech, CBN came to carry out an audit. That was the first ever audit they carried out for that organization. And next thing, I was just on my own doing my normal legal routines. And I got, the founder sent me a link, join this. CBN is on the call. Please answer whatever questions they have. I was like, what is it about? What is it about? So that I can prepare. They said it's about some compliance stuff. I know you can answer it. And lo and behold, it was for data privacy and data security. And they started asking, they said it's an audit and it will commence the next day. These are the things they needed. So if not for the initiative I took, we would have been embarrassed. I particularly would have been embarrassed. So that was how I was able to scale through that audit with a 90%, yes, 90% score rate, with some other technical and organizational measures that we missed out during the process. And that's when the board came on board. So why am I saying this? I'm emphasizing on this because we are all in one way or the other giving legal advisory services to fintechs, and they rely on us. So it's important that we emphasize on the need for a DPO. Then also registration of the data controllers and processors is mandatory. It's covered under section 29 and 44 of the NDPA. This creates a formal inventory for all entities processing data. And very soon, the NDPC will clamp down on organizations that have not been registered. Another aspect of legal accountability is the compliance audit and appointing a DPCO. Now, this compliance audit return is a yearly thing. The DPCO is an expert, that's the Data Protection Compliance Organization. They are licensed by the Commission to carry out, they have expertise in carrying out these audits, right? So what an organization is supposed to do is, on a yearly basis, they conduct and file periodic returns, audit returns. So this audit is a legal documentation where you formally prove your processes and safeguards meet the NDPA benchmark. So that's when you bring out your policies, you bring out all the evidence of your security and organizational measures, everything concerning data, data privacy and data protection, you bring it out as evidence. Then you now have the data protection impact assessment. I'm sure the second speaker will talk more on these technical aspects, right? So essentially, a DPIA is a process of identifying and minimizing privacy risks, right, associated with data processing activities. So, and this DPIA is conducted where there is a high risk involved in the individual's rights and freedom. So, for example, like I mentioned earlier, for companies that process biometric information, you are held to a higher standard, right? So DPIA is compulsory. So it's a special type of risk assessment audit. So imagine a client wants to deploy an AI surveillance in a shopping mall. That's a high risk. So before you buy cameras, they must conduct a DPIA, because you're going to be taking certain personal information of people around, images of people around, their biometric configuration. So DPIA will assess these privacy risks, and then it's mainly, I call it privacy by design. So essentially, before you even go live on any app, you must do a DPIA, because you cannot be fixing data privacy concerns when an app is live. It has to be done before the app is launched and also afterwards. So it's a periodic audit and a risk assessment audit. So it essentially helps with risk identification, risk mitigation, legal compliance, and also helps with continuous assessment of processing activities. The final aspect of legal accountability is the enforcement. So you will be held accountable when you do not adhere. And part of the accountability is penalties and liabilities. So let me just give you a visualization of what these penalties look like. Imagine Zenith Bank or MTN being fined 2% of their gross revenue. Imagine just 2%. It's going to run into billions of naira. So this is why it's important that we make data privacy a top-tier governance issue within our organizations. Beyond the fines, there is risk of class actions. In severe cases, criminal liability for officers. So we're going to move forward now. Now that we understand what the legal accountability is, we move forward to data compliance, which is the second part of our discussion. Please, if you can hear me, let me know, because I've been speaking for a while. You can put an emoji just to let me know. Thank you for following. Thank you. Amazing. So I hope I'm not speaking too fast. I think my time is almost up anyways. So what is data compliance? That is the other side of this discussion. So it's the operational and procedural adherence. So in as much as data, if accountability is the principle, compliance is the process. So we have to be accountable by providing evidence to demonstrate our compliance. Compliance now, I'm going to put you through the practical aspect of data privacy and protection. So it is the operational adherence to the rules. Demonstration of evidence is one thing. Operational adherence is an activity, is an action word. So the core pillars of data compliance is the lawful basis, that's justifying your processing activities, the principle of adherence, security, timely reporting, etc. So we're going to delve straight into the data compliance, the concept of data compliance. The first one is the lawful basis for processing personal data. Before you process personal data, you must have these key lawful bases globally. It is not a Nigerian thing. Globally, I'm sure most of us sit on international boards. We are compliance officers and chief compliance officers to international organizations. There is a similarity, a global similarity in the lawful basis for processing personal data. And this is contained in Section 25 of the Nigerian Data Protection Act. So you cannot touch data without any one of these bases being present in the reason for processing personal data. So I'll just run through it quickly. Consent, explicit, specific, clear, unambiguous. I particularly pick those words so that we understand that it must have certain criteria. So you saying by reading this, you consent to the processing of your data. By giving your name and your information, you explicitly consent to the processing of this data. That doesn't work. The person has to give unambiguous, clear, specific consent towards that processing. Then a contract. There must be a privacy policy that the data subject accepts. So it is necessary, the principle is that you are processing the data, they are processing this personal data for the performance of a contract. Sorry about that, the mix-up. So this performance of a contract is one of the bases for which you are processing data. So let me give you an example. You are processing data to provide me with a loan service. That is a justification. So if you process my data for that purpose, you are not doing anything illegal. You've collected my consent, yes, at onboarding. Then what is another reason for collecting my data? Because you need to render loan services to me. Another reason for collecting personal data and retaining it is to carry out a legal obligation. So like I said, the right to be forgotten is not an absolute right because there are legal obligations that fintechs need to adhere to. And one of it is the AML regulations, AML laws. So AML laws requires that 6 to 7 years after the termination of any service or any contract with a customer, you are to retain that information for that duration. So even if a customer comes to you to say, oh, I don't want to transact with you anymore, delete my information completely, you are unable to delete that information because you have certain legal obligations. But as long as you have that information, you are under a legal obligation to protect it because it's still within your possession. Another lawful basis is vital interest. That's necessary to protect the life of a data subject. Another one is public interest. So it's necessary for public interest to exercise official authority. And then we have another one called legitimate interest. So let me give you an example. A company installing CCTV for security relies on legitimate interest. However, they must balance this against the user's rights. So installing CCTV in a banking hall is legitimate. Installing it in a changing room is not. So even if you have the legitimate interest to install this in a banking hall, you must put a notice so that people know they are being watched. So if I know I'm being watched and I don't want to come to Zenith Banking Hall, I would decide not to. You are giving me a choice. That is another aspect of legal accountability that flows into data compliance. Secondly, we have the principles of processing personal data. I call it a statutory duty of care. So now that you have the lawful basis, because you have an app that provides loan to people, right? You've already collected their consent, you have a contract with them to deliver certain services, e-commerce services, loan services, and stuff. You have the lawful basis. What now is your statutory duty of care? And that is where the principles of processing personal data comes into. Now we have a few principles. Let me just try and get that. Okay, back to my slide here. So we have a few principles that we'll be discussing. So for time, I would not really expound on it, but I will share the slides definitely after the webinar. We have the lawful fairness and transparency principle. That is the bedrock of all processing. That is the bedrock. It requires valid legal basis, which is under Section 25, right? It's the bedrock. Whatever data you are processing, it must be lawful, it must be fair, it must be transparent. Fairness talks about, transparency talks about putting it out there. Privacy policy is an example of transparency. Let people know that you are collecting their data. Don't try to collect data through the back door. Let people know the type of data you're collecting and what you're using that data for. Purpose limitation. So when you collect data, you should collect it for a specified reason, explicitly state the reason, and also for legitimate purposes only. We call it the no function creep. So imagine a hotel that collects your phone number from room service, and then they now later sell that phone number to a taxi company for marketing without collecting your consent. Because initially you gave your consent, and you gave your consent for a particular purpose that you were informed about. So imagine them giving it to a third party, and then they start marketing a taxi service that since you're in the hotel, if you need a taxi, you can call us on this. That is illegal. So that is where the purpose limitation comes in. Whatever you are collecting that personal data for, use it for that particular purpose alone. Do not use it for another new purpose without collecting a new consent. Then we have data accuracy. Ensure that all data within your possession is accurate, complete, and is kept up to date. We have data minimization. Still under the principles of processing personal data. Processing must be adequate and relevant. It must be limited to what is necessary. Quote and unquote, limited to what is necessary. So we should always have that at the back of our mind. So collect only what you need. Do not ask customers for their religion if you are selling them a pair of shoes. If you're selling a loan service, why are you collecting their religion? You can do that if you're a church, if you are an NGO that deals with religious activities. But we should be able to map out. That's why we have a record of processing activities in data compliance. You should have a roadmap. You should have a documentation as to what data is needed to provide the services to that customer. So another aspect of data compliance is security. That is implementing technical and organizational measures. I will not delve too much into it because I believe our second speaker would speak about that, but it's providing certain technical and organizational measures. For example, security, encryption, right? Encryption, access control, cloud security. Those are technical measures. Organizational measures, policies, SOPs, things that will guide the employees that are handling this data to ensure that they are able to carry it out effectively. DPIA, those are technical and organizational measures. So compliance demands a risk-based approach to ensure that the safeguards are proportional to the data sensitivity. Like I mentioned earlier, if you are collecting sensitive personal data, you are held to a higher standard duty of care, right? You need to carry out a data protection impact assessment. So that is compulsory for those that are collecting sensitive data. So this implementation of technical and organizational measures ensures data protection. Now, we also have the data breach notification. So if security fails, like I said, security is not 100%. These hackers, if we move one step forward, they move 2 steps forward ahead of us. There is no 100%. There is a minimum threshold required. There is a minimum threshold.
I'm supposed to inform you that you are way out of time. Could you please
God.
wrap up? I can see that the audience is very engaged, and so I've been thinking of how to interrupt you. I can see in the comment section. Yes, please. But if you can just breeze through it so we can go to the next speaker. Thank you very much.
Thank you so much for your time. Data privacy is huge. When I was told I had 30 minutes, I was trying to wrap my head how I'll be able to explain that you will understand and still keep to time. So, well, speaking on the data breach notification, it's a requirement that once there's any breach, 72 hours, you notify, right? There's a 72 hours window of notification. So failure to report a breach in itself is attracting significant penalties. So as DPOs, let's have that at the back of our minds. So now that you know what legal accountability is and data compliance is, why does privacy matter? Why does privacy compliance matter? Why? Mitigates privacy risk. Like I told you, if they hack Money Point today, the damage will be catastrophic because they hold, I think, more data, more financial data, more data of Nigerians than any other fintech in Nigeria. It will be catastrophic. So data privacy compliance helps to mitigate these risks. It enforces accountability. You know, before now, I explained that it used to be, data protection used to be a fancy word, an international foreign word, best practice, best practice. NDPA and guide have made it a statutory obligation that any data controller or data processor must adhere to. So it enforces accountability. And we've seen the principles around legal accountability, and it unlocks global market access. When you adhere to the NDPR standard, which mirrors the GDPR, it acts as a data passport. So currently, a lot of foreign investors are able to come into Nigeria because we have a minimum threshold that aligns with their own regulation in Europe. So this data passport is what we have been able to achieve by the enactment of the NDPA. So finally, in conclusion, this brings us to, so what? For us lawyers and for privacy practitioners, data compliance is no longer an IT concern. It's a core legal risk. So we must move from being reactive to proactive. The onus is on us to move from being reactive to proactive. We must advise on DPIs before product launch. We must be able to draft robust data processing agreement, and we must guide the board on financial implications of non-compliance. That is imperative in our practice as data privacy practitioners. So data compliance, like I said, is not just an IT concept anymore. There are a lot of risk is attached to it. And on the board level, please ensure that you bring them up to speed on the importance and the mandates of data privacy and protection. Thank you for listening. And I hope that this has clarified the abstract nature of the law and you have an understanding of the practical accountability that is required of us as privacy practitioners. Thank you. I'm happy to take any questions, if any. Thank you so much.
Thank you so much, Mr. Jackson Okocha, ESQ. You've done justice to this topic of discussion. I've been following the discussions in the chat box, and it has been very enlightening for all the members here present. Thank you so much. So at this point in time, without further ado, let's move on to our next speaker. Our next speaker is Stephen Alekwe, and he's going to take us through the more practical technical and implementation aspects of the topic for discussion today. Sir Stephen, over to you, please. Unmute your mic. Sir Stephen, your mic is still muted in case you're speaking. We can't hear you. Thank you.
Yeah, good afternoon. Good afternoon, everyone, and welcome.
Good afternoon.
Welcome once again to this session. I appreciate you all for this platform to share and let's discuss data building digital trust. Okay, I think I can share my screen right now.
Sir Stephen, are we still on track? We can't see your slides yet.
Okay. Okay, so good afternoon, colleagues and professionals in the industry. Don't know why, I'm just get to my slides right now. Okay, so I believe you can see my screen right now.
Yes, we can
Can you
see
all
your
see my
screen, but if you can put it on full screen mode, it will be easier for us to follow through.
Yeah. Okay, so
Thank you.
good afternoon, professional colleagues, and welcome once again. I know I'm speaking to learned colleagues right now. So it's my pleasure to have this conversation or discussion with us. Let's look at how we can build digital trust through data governance. All right. So at this session, we're going to have some, look at some industry perspective. How best can we, as lawyers, as legal practitioners, see how best we can make our impact into the ecosystem. All right. So don't forget, we're in an ecosystem where digitalization has come to take the center stage. And just like my colleagues Jackson Mercy has, earlier reiterated, data has taken the center place. We can see that data has become the lifeblood in practically every sector, every industry, and in all our dealings, right? So taking good care and handling data in a very proper way is it's no longer, oh, let's meet that compliance requirement. It has become an imperative that we must actually, all get ourselves in tune with. That said, so we need to, as lawyers, we are now at that center place in trying to see that we protect and see that management and handling of data as critical resources are being paid attention to. And in all this, proper data governance, it's important. That's why you see there are regulations springing up from different sectors, from different jurisdictions, all centered around seeing that best practices are maintained. All right. So, and knowing truly well that data governance actually power trust and accountability and digital confidence. In practical terms, is the fact that, before now we can say, okay, we relate to ourselves as physical beings, right? But as we are today, in all our dealings, just the way I have a physical presence here, I actually also have a digital footprint. And it's very key that we see to the fact that, trust is maintained. And in all, you can see that trust becomes the most valuable currency with which we can actually traverse, the ecosystem or the digital economy. All right. So, and we're all seen as digital citizens. All right. So the objective of this session basically is to see how best we can get clearer understanding of data governance as a toolkit to, building trust. And trust being a universal element, we need to see how best, can also extend it even in the digital space, right? And being practical as legal practitioners, our engagements and our activities, actually in the center place where everybody sees us as, a point of anchor where we can, seek clearance, seek clarification and all that. So in the digital space, we will not be absent. We actually need to also, present and see that where tools and technology and stuffs are used, we are also meant to be present as well. Okay, so at the end of this session, we expect that, we want to be able to achieve two things. See that we foster best practices and then have a cultural shift. That's the idea. So, we see to the fact that we provide practical guidance on data handling best practices and secure data management, so that we see that from end to end in the data lifecycle, proper best management practices are put in place. Also, we have that cultural shift where we now see, our activities as already a part of us, embedded in us, so that, we foster that culture of data protection and privacy across all level and nature of our client engagement, right? So that's what we intend to achieve at the end of that. We'll be able to look at some key areas around what governance is, why trust is a core outcome, and then practical governance structures that we can actually model our activities around, and then legal and regulatory alignment that we can put in place, and then practical roadmaps towards achieving this. The truth remains that these are not abstract discussions. They're actually things that relate to us, or we relate to it in our daily engagement, in our daily activities. Okay, so we must be able to see how best, in the first place, what is our focal, what is our focus when we talk about data governance? Really, from an industry lens, basically you look at data governance as, has to do with frameworks that ensure that data is accurate, secured, usable, and accountable throughout its life cycle, right? So it becomes a trust-building mechanism, enabling responsible data handling. Because the truth remains that, data handling is it should be such that we all must see that our data at different hands, are properly respected. And there's this saying about taking control of your data, all right? And that's where, just like Messi said, you look at data handling from two angles, right? The privacy aspect of looking at its rights, and then looking at it as the right of individuals, and also in the angle of protection, looking at the obligations given to the data controllers or processors. So in this angle, we must actually see that proper data handling is in place. So governance has to do with, how are all these things handled, all right? So, and our focus also, we see it that these things, governance can be achieved through the use of policies, through human beings that are in the center place, seeing to the implementation and proper handling of these things, ethical data handling, see that processes are also put in place so that in the course of the processing of personal data and all that, there are no misuse or exposures that will lead to violation and stuff like that. So it's important, we pay attention to this, being legal practitioners that we are, and then the use of technology. The introduction of technology ideally, helps to, bring some, helps to facilitate and enable processes. However, it also comes with its own area of baggage of some exposures to the data handling process. So in the course of this, there's every need for us to see that, we maintain proper data handling such that the introduction of technology should be able to carry out what in data governance we refer to as, data privacy impact assessment. What are the implications? What are the impacts of the introduction of this new technology to the processing in terms of the privacy rights and the privacy data protection of the data subjects within the ecosystem we play with? And at the end of the day, this will help us in strengthening our client confidence and credibility, because governance is not just a compliance checkbox. So it has become business imperative, something we use to take out to, position ourselves, to be ahead of competition. All right. So every organization, individuals of data subjects, oftentimes are focused on organizations that respect their privacy, right? So that makes it an important aspect, okay? So data governance has evolved from a very regulatory compliance aspect or initiative to that customer or client trust imperative that ensure that responsible use across the data lifecycle is the focal point, okay? So then that is why it is important to us, as practitioners in the space, to see that we maintain good practices so that we can take advantage of the process, not the process or the invention or the state of the economy relegating us to the background. We are actually leaders in the space. So, and that is why we must see to the fact that we use proper data handling practices to be able to position ourselves better in the ecosystem we serve. All right, so these are why the data governance are actually of importance. You can see in today's world, there is rise in data breaches and misuse, because people are beginning to, see the value of data. So exploitations are happening. People are exploiting different avenues, to make value, much more value out of data. So, and you see that people are trying to either get data through legal means. You see that data are now sold in the open market. Okay. Before now, a lot of us don't know the importance of, just being enrolling on Facebook. But the fact that you are just, you have a Facebook profile, okay? That your profile is already valuable asset to the owners of Facebook. All right. So your little clip, no matter what, whether you are idle or active, Facebook makes money from your profile. I'm just using that as an example. All right. So imagine the value of the kind of enrollments and registrations, and our presence in different applications and all that, how much value it gives. All right. So our clicks, our presence, our online, viewing of profiles or visiting websites and stuff. So these all have values that, the right persons, looking for value from them can actually gain that. All right. So, and then there's increased reliance in the digital technologies, because practically in today's world, in whatever sector you play in, if that organization does not actually take advantage of technology, technology will take advantage of it. Okay, so, and it's practical that technology adoption has made it very critical that, we pay attention to the data that are the engine, that are the major inputs that are being processed to actually get outcome. Okay, so these are key aspects to pay attention to. And then, legal and ethical responsibilities. Like I said earlier, a lot of regulations are springing up every day from different jurisdictions. There are sectoral regulations, there are jurisdictional regulations, just as we have it. Yeah, before now, I know in 2018, when the EU GDPR became very prominent, everybody was like, oh, you can see banks started adjusting their account opening packages, organizations, just to be able to see, to get in line with the requirements of the EU GDPR then, right? And as we are today, most people don't even pay attention to some of the forms and contracts and engagements that they feel, because ideally organizations are meant to also see that they realign their documentation such that they also get it to be in tune and in line with the compliance requirements of the Nigerian Data Protection Act, which is the primary regulation guiding personal data handling in Nigeria and for Nigerians and all residents of Nigeria. So it's important these are brought to the fore, and we also look at it critically as legal practitioners. We are seen as the go-to persons, for advice, for direction, for advisories on what to do and how things should be done. All right, so we should actually open the eye of our clients to this, and then see how best things are better done in that aspect. Okay, so we look at also the fact that trust and reputational values, are of critical importance in today's world, because reputation is very, very difficult to build. But with just a little action or inaction of a member of your team, can actually erode the entire reputation and trust that you have built over time. And that could be as a result of what could not be done or what was done the wrong way. Okay, so it's important we pay attention and see how best this works. Okay, let's look at a Nigerian bank who, for instance, okay, we know that all these are organizations and financial institutions that we relate with. They collect a lot of our data. They have our financial records and logs. And I'll also tell you, other organizations, from the other hand, are also in need of this data, to be able to use it either for marketing purposes, for research purposes, and for other things. So, but one primary thing is, before those data are used for those other marketing purposes, they need to be properly deducted. The personal information elements of them need to be removed, so that you cannot directly identify any human being by virtue of, just what information is there. So it's expected that before this data are sold or transferred to other users, the legal advisors should be able to more or less see to the fact that they advise the company on lawful basis under the Nigerian Data Protection Act. And it's important to point out that lawful basis are quite depending on where you are coming from. Based on public mandates, if you are a public organization, public sector organization, it could be based on contracts. It could be based on, vital interest, right? So it could be based on, so it's not only consent. Consent most times comes as the last resort. There should be other bases for data processing outside consent. All right, so where there is no consent, you sought to exploit the fact that consent is the basis. Anonymization is key. Anonymization requires removing personal data elements in that data just to be able to use it without re-identifying the individual, right? So it's important to pay attention to it. So now, what are the imperative, the trust imperative? Basically, the point remains that as individuals, as customers, as clients, as people who relate to on a daily basis, we always want a situation whereby we relate with organizations that protect our data as individuals, as data subjects, that are transparent about data usage. Tell us what you are collecting our data for, right? An organization, an individual will always want to be, so in their privacy policy, they specify what they collect, how they collect it, what they use it for, who they share with, and stuff like that. So these are important to be made known to the data subject. It helps to build confidence and loyalty, right? So they are after those kind of organizations that also show them, that proper also maintain swift incident management system, because they want to see that there are proper measures in place to ensure resilience, and continuity, even in the face of attacks. All right, so you want to see that you have proper structure, security measures, and when we talk about security, we look at it from both technical and organizational, right? What do you have in place? Do you have data loss prevention mechanism in place? Do you have encryption in place? You have your websites, secured end to end. So these are all things that need to be in place. In terms of organizational measures, what policy, what access control measures are in place? These are all what we should do in terms of the data governance that we put in place to ensure that these are maintained. All right. So some of the key pillars, that will help us build a trust-centric data governance is to ensure that we maintain transparency. All right. Let it be clear. Let our communication and relationship with our data subject or the public that we relate with be clear and specific. All right. And then accountability is key. You must not just be accountable, you must submit yourself to be accountable. You must show that you're accountable both in deed and action. All right. So it's important that we define roles and make them measurable such that everybody knows what they need to do, and then follow regulations. We have the Nigerian Data Protection Act that has required that every year organization file annual audit. This needs to be maintained, right? Integrity. Let's maintain accuracy of data, at all times so that they can be reliable and of high quality. Because data in your hands that are not reliable and usable, they are not that valuable. All right. So the integrity of data must be maintained. All right. Strong controls and privacy by design measures must be there. All right. So, and then the fact that we maintain compliance. Compliance is key. We don't do compliance because they say we should do it. Compliance also adds values to our businesses. And that's why they are just important that we get them. And we must not forget these four critical components that are helping in driving the model. The people, and in terms of people who define roles, identify roles, and give people ownership and hold them accountable for it. So the people are key drivers in this. Does the organization have a DPO? Create data owners and data stewards and custodians. Create data champions, right? Let them be the ones, because in this industry, you cannot do it alone. You can't say, oh, we have a DPO, so let him. So by the time there are responsibilities and there are other people that get the system charged, all right? So everybody does what they are supposed to do and the system gets better at it. Okay, so it's important, that is paid attention to. Now, in terms of technology, I've talked about what are the measures in place. We have data loss prevention mechanism to have in place. The identity access management. What we have that in place? We have security information and event management. How are they put? GRC, governance, risk and control measures. What do we have in place to see that we're driving the process? In terms of process, have standard operating manuals in place. And then of critical importance is data protection impact assessment. For every time you have process change or introduction of new technology, it's important that you put that in place such that within the life cycle of data, we ensure that they are secured. And then ensure that you maintain bounds in terms of what you collect, how you collect, and for how long you keep them. When it is the expiration of the retention period of data, also ensure that secured data destruction process are maintained. These are all different domains in data handling and management that we must make sure that they happen. Today, data is the oil, and we pay attention to it with all sense of importance. Okay, so in Nigeria, looking at the legal and regulatory landscape that we must pay attention to. Mention the Nigerian Data Protection Act. Mention the fact that there is a licensing obligation that has created the DPCOs, the Data Protection Compliant Organization, which most of us are actually playing within that space. All right, and the NDPC sees to that licensing and sees to the fact that organization maintain that. There are some data subjects and their rights must be maintained, and properly, kept. And the fact that cross-border data transfers are paid attention to. Must pay attention to cross-border data transfer. And the sense behind it is, if our jurisdiction maintain proper security and protection around personal data, wherever our data is used outside the borders of this country, we must also ensure that that area has adequate regulations to be able to provide protection over the data that are being shared. Okay, And that's why.
Thank you. Thank you so much, Sir Stephen. Just wanted to inform you that we are running out of time. So please, you can start rounding up your presentation. Thank you so much.
Let me be giving my final thoughts. Okay, so
all right.
I want to talk about the alignment of practical guidance. Let's share as individuals, let's all as individuals, as legal practitioners, as practitioners in the ecosystem, see how best we embed compliance in our workflows. All right? Because if we make it a part of the process, it will not be difficult to actually maintain. Let's conduct routine assessments and audits. All right? There's the requirement that say conduct annual data protection audit. So let's ensure that that is done. Maintain verifiable documentation, right? These are practical guides that in the field we go today, we see that organizations don't maintain documentation. So you start asking questions and people are saying, oh, we don't know. You know, as simple as carrying out an inventory of personal data processing. A lot of organizations don't have a comprehensive record of the kind of data they. And we'll talk about ROPA, record of processing activity. A lot of organizations don't know, but we need to, preemptively or proactively, get that to be in place and maintain up-to-date privacy notices. Privacy notices are not just, putting up jargons, on the space and say, let people, if it's not readable or it's not comprehensible by your target audience, then it's not of value. Right, so incident response and escalation paths have been created. So we need to also make sure that we adapt and get our organizations to get into it. We understand some challenges and we can always have a work around them. Right, so the practical solutions just start by having a maturity assessment. Where am I? Where is this organization? To what extent? Where can we get started? All right, simplify your processes, make it human readable. Let the policies be such that we don't have to, put a lot of words and all that. Let's simplify it and get it to be readable. There are simple formats, that can be followed. And let's implement, what we said we're going to do and then get them done accordingly. All right. So I want to say a very big thank you to us. I know I wouldn't have loved to quickly round up. So if I have 2 minutes, I'll round up.
Please go ahead and round up. Thank you. Sir Stephen, you can go ahead and round up.
Okay, that's fine. Okay, so basically we have a trust building culture that we think we should all do. If we sanction it from the top, it will be easier to cascade down. So even in our engagement, in our relationship with clients and organizations, let that leadership endorsements come from top down, right? It will be easy to actually cascade and ensure that it goes down. Ethical data handling, let it be one of the core values we enshrine in our relationships and in all we do. How do we do that? Just preach the fact that these data, as much as they pass through you, they are not yours. You're only a custodian. Handle it because you have that fiduciary relationship with the people that entrust it in you. That have access to data of people does not mean that I should consume them for my personal self. It's for my organization. It shouldn't be for my own consumption. So we have that kind of mindset, so that people don't circumvent processes because they've come across data and they now farm them for their personal use. All right, let's encourage whistleblowing mechanism so that you see that, oh, your your colleague or, is going to put your organization into trouble. We'll have that avenues where some of those things can be filtered to the right decision makers, where they can take actual action about what should be done. And then it is our collective responsibility. Let's have that, stewardship mindset where we know that what you do, what I do, we all are involved in it. There's this saying that, we are as strong as our weakest link. So we need to all educate ourselves and then share, this idea. Okay, I've talked about enablers, technological enabling assets that we can put in place. Talking about data discovery and classification tools. Let's adopt those kind of things that can help us, actually have a clear definition of different class of assets that we have. Table that can, give us that dashboard view of what it is. Identification and access management that must be put in place. Who is who and who should have access to who. Define roles and responsibility and access rights. Okay, data loss prevention, as well as privacy management platforms. This will help us to, do what we need to do. And in fact, we are in an AI world. Most of these things AI can help us. And that's also adoption of AI must not throw caution to the wind. Because as much as we throw data into the AI, we're also training the AI. So let's look at AI-driven governance automation that can help us to streamline processes, reduce the rework, and see that, we have a clearer dashboard that can help us. So as a matter of fact, roadmaps that organizations should take, let's assess the current state. I'm re-emphasizing this so that we can help us, in our respective spaces, define governance objective. What do we want to achieve? What are the obligations we must meet? What are the regulations we must follow? And the fact that we must build policies and structures in place. If it's not properly structured, people just do what they want to do or do what they can do. And at the end of the day, we find ourselves on our knees. All right. So implement controls and technology. It's not everything that passes that will buy and adopt. They say you can use AI. It's not every AI that you must use. Let's also train our employees, train our human resources on what to adopt and what to throw in and how best to have this. All right, training and operationalization of these processes is important. We cannot stop training. We cannot stop engaging. We cannot stop discussing about it. All right, because these are ways that we can ensure measurement and continuous improvement. Okay, so these are important that we must do, and the benefits are quite enormous. It will help us to actually take that leadership. All right, and at the end of the day, we are all good at it. So my final thought would be that data governance is not checkbox. It is a trust building engine. All right, so let's all follow that. Organizations that master governance, actually lead in the digital age. We want to be leaders. We don't want just to be followers. And then trust ends through consistent and intentional and strategic data practices. We should be seen to be involved in that engagement. So I want to say thank you to all of us, and I will leave us with this. What can we say is the problem with this nice truck traversing the Nigerian road? Okay, just in closing, because the point remains that we are strong as our weakest link. We have all this security in place. If the user or one of us, it could be the cleaner in our office, it could be the security man, it could be the MDCU, does not understand what we're doing, may not understand the importance of the data or the information or the lever he or she is holding. And at the end of the day, it will throw all of us into chaos. And that is why it's important to maintain proper training and continuous training and capacity development. That will always help us. And that's why I appreciate what we are doing here and why this is a continuous thing. I give all of us a round of applause for this kind of
Thank you so much, Sir Stephen.
All.
Please, a round of applause for Sir Stephen. We can just put the clap emoji in the chat box. Let's appreciate all of our speakers today. Let's appreciate Mrs. Mercy Jackson Okocha and Sir Stephen Alekwe. Thank you so much for sharing your knowledge and insights with us today. And thank you also for breaking it down for us, making it practical, easy to understand, and relatable, especially from our perspective as lawyers. You also mentioned how important it is to have training, especially as part of data governance and even as part of the legal obligations in the NDPA Act. Training is very important, and that's why we're doing what we're doing today. So thank you so much to our speakers. At this point in time, we would like to take the questions that were left in the chat box. Starting with the very first question. The very first question and the most popular question is about the slides. Will the slides be shared? May I call on Oluwa Damilola? Damilola, please confirm that the slides can actually be shared, because the speakers have made their slides available. Please confirm that they will be shared. Yes, they will be shared. Thank you very much for that response. So everyone who is on this call is going to get a copy of the presentations that were made today. The next question that we received in the chat box is, what are the available courses and certification in data protection? I will let Mrs. Jackson Okocha speak about this. Mercy, are you still on the call? Please unmute your mic and give us an answer to this question.
Hi, thank you so much, Dara. So yeah, there are a few courses, right? Some are on Coursera, then we have some from PECB, then we have some from that's the CIPP as well, certifications. So there are so many of them. You just need to just do your research. But CIPP is is a professional course where you get a certification and a title, right? So, and that's more expensive. So if you're new to data protection, I will advise that you check out Coursera, check out Allison to build the foundation of your understanding before you proceed to taking any more professional courses.
Okay, I think I would like to also add, in the ecosystem itself, there are a lot of certifications. Nigeria has the Data Protection Authority for Nigeria, that's the Nigerian Data Protection Commission, in its wisdom, has also come up with, a national certification body for data protection officers, right? So it requires going through some trainings and taking the certification exams, and these are basically around the Nigerian law. That's the Nigerian Data Protection Act. So in addition to all the different certifications we have, to be able to practice as a data protection officer, you are meant to have that indigenous certification that tests Nigerian primary law of data protection in Nigeria, right? And by extension, there are other certifications, including Certified Data Protection Solution Engineer by ISAPA, right? So these are, there for us to explore, and, get our hands on. And these are practical and practice tools, certification that will enable you to practice in the ecosystem and also serve as an authority in the space where you, right? Just an addition.
Thank you so much, Sir Stephen. So just to reiterate what the speakers have said, there are various trainings and certifications that you can choose from. If you want free courses, you can check on Coursera, Udemy, you can find some free courses. If you want to do a Nigerian-based certification, you can reach out to, I don't mean to do any free publicity for anybody here, but I think that it's important for us to know the kind of resources that the NBA SLP has made available to us on this call. One of our speakers is a licensed data protection compliance organization and an accredited training organization by IIM. So that means you can actually reach out to him if you would like to get the training and certification to become a certified data protection officer in Nigeria, according to the Nigerian law. You also have PECB, which is according to GDPR, as well as IAPP. So there are so many options out there, and please feel free to choose whichever one aligns with your professional goals. Moving on from that, there's a question in the chat box saying, please, what is the modality for claiming CPD credits for this session? Is Damilola on the call? Do we have a member of the committee or the subcommittee on the call, someone who can give us an answer to this question? Do we have someone who can give us the answer to the question about CPD credits for this session? I believe there was an announcement made at the beginning of the call asking people not to share their personal information, such as their names and their Supreme Court numbers, because it would be done automatically. So that should answer that question. It will be sorted out by the committee. The last question we have in the chat box goes like this. It says, in government hospitals, patients are not given their files and their results after they run tests because the results are sent to the doctor's email. Is this not a breach? I think this question would be directed at Mrs. Mercy Jackson Okocha. Please, can you give us a quick response to this question so that we can round up this session for today? Thank you.
Right. Okay, yeah, thank you. So yes, I would just say it's part of ignorance in terms of data compliance procedures in government hospital. So what can happen in this case is that you just simply write a letter requesting for your personal information and your medical details. So ordinarily, what they try to do is they will tell you that the file is with the doctor or something of that nature. But when you write to them formally, you have a right under the Nigerian Data Protection Act, like we discussed, to request for your information, to know what they hold about you. That includes your health information. So please go ahead. You can get a lawyer to write to the hospital and you will get that information. Thank you.
Thank you so much for the very concise and straight to the point answer to that question. So I believe at this point in time, we've gone through all the questions in this chat box. We will now move to the next agenda for today, which is the closing remarks from Fernandez Marcos Obiene. Is he on the call, please? Fernandez, are you on the call? Please unmute your mic and give us the closing remarks.
Thank you. Hello, everybody. Good afternoon. This has been one hell of a session. I've enjoyed it. And I'm sure that you enjoy it. So please, virtually, can you put our hands together again for the speakers? Well, thank you very much. It's only 2 people that are clapping. I thought I have like 16 claps or 20 something or 30. So yes, thank you very much for taking your time to join this session. I also am grateful to the speakers for taking their time to give us, like I said, very superlative performance, something that I'll remember for a while. Of course, the recording will be available. It will be sent to you via email. What do they call these things? The slide presentation, slides rather, will be sent to you too via email, along with the report of the session, so you can expect to get that. We're still going to be having another session next week. The name has slipped my head, but we have another session next week Thursday, so look out for the registration link so that you can join, and you'll be interesting too. As usual, these sessions are free for members of the SLP, but paid for those who are not members of the SLP. So please do well to register and join the SLP so that you attend all this free with our CPD points that come along with it. I thank the moderator for this session, Chidera. Thank you very much for doing your work. I also thank the the entire team really for putting this thing together. The committee specifically. I don't know if the chairman of the technology committee is here. Is there anybody from the committee, from the subcommittee?
I don't think he's on the call. He mentioned that he won't be able to join the call.
Okay.
Yes. So
I
I'm
thank
here
him
though.
very much. Okay, thank
You're
you very
welcome.
much too for that. We're very grateful. So that's it. Not to take some of your time. You didn't come to listen to me say thank you. So my name is Fernandez. I'm chairman of the Technology, Media, and Telecommunications Law Committee of the NDPA Section on Legal Practice. And I wish you a wonderful month ahead. Thank you.